Okay, we ready on Evans?
Yes, we are, Judge.
All right, sir, what's your name for the record, please?
Charles Anthony Lionel Evans Jr.
Thank you. This will be case 24-056236, State of Michigan versus Charles Anthony Evans Jr. Counsels.
Good morning, Your Honor. Aaron Wilmoth, P82085, appearing on behalf of the people.
And good morning, Eric Osdy on behalf of Mr. Charles Evans.
Thank you. Do you waive formal reading?
Yes, we do. Waive formal reading of these charges and stand mute at this time.
Court will enter a not guilty plea on your client's behalf as to bond, beginning with the people.
Your Honor, thank you for allowing the people to address bond today. I do want to address a couple things with the court when thinking about bond in this case. First, I want to talk about the seriousness of the charges, which clearly are evident on the face of the complaint and warrant. Mr. Evans is charged with 1 count of felony murder and 1 count of child abuse in the first degree. And obviously more information will be presented at a preliminary exam. This isn't an exam, this isn't a trial, but in general, the court should know that these allegations do arise out of the death of the defendant's biological daughter, Kinsley Evans. She was a mere 9 months old at the time of her death. This incident occurred back in June, specifically June 26th of 2023, at the apartment of the defendant that he shared with his then girlfriend, Jemai Wilson, and his other biological children that he shares with Jemai Wilson, who at the time of that incident were 3 months old, 1 year old, and 2 years old. And they lived at that apartment and were present on that specific date. How the decedent, Kinsley Evans, became into the care of Charles Evans was over Memorial Day weekend. Kinsley Evans's mother, Keandra Irving, dropped Kinsley Evans off at the home of Mr. Evans so that she could spend some time with him. When Keandra attempted to retrieve her daughter from Mr. Evans refused to return Kinsley Evans to Keandra. And this is supported by evidence in the case, including incident DPD police reports, evidence from phone extractions, and Keandra Irving was actively seeking assistance from CPS and the family courts because Mr. Evans was refusing Kinsley Evans back to Keandra. Obviously, the allegations are serious. The medical examiner's report lists multiple life-threatening injuries to Kinsley Evans, and the medical examiner also lists injuries that would support the main cause of death was strangulation, asphyxiation. Again, more information about those injuries will be presented at the preliminary exam. My main concern here, Judge, is some past incidents that reflect that Mr. Evans is an absolute danger to the community. This defendant in particular is extremely, from the people's position, very dangerous. I want to point out to the court that Mr. Evans had a previous assault with intent to murder case. This was in 2018. It was a domestic violence assault with intent to murder case, wherein those allegations involved that Mr. Evans shot his ex-girlfriend multiple times in the right side, and then when she fell to the ground as a result of being shot, he walks up to her and shoots her again in the abdomen. This particular complaining witness testified under oath at an exam and absolutely stated that Charles Evans was the person who shot her. Now, mysteriously or not so mysteriously, as we see in DV cases all of the time, right as the case was ready to go to trial, the complaining witness recanted. But what is interesting, Your Honor, is that through the evidence of the phone extraction, Mr. Evans makes a comment to Keandra Irving while he is threatening her that talks about how if she's going to try to leave him, don't worry, he has shot a bitch before. Also, as a part of Mr. Evans' history, he has two convictions wherein HIDA was revoked. So the people were not able to habitualize the complaint and warrant because the HIDA was revoked after the date of the incident in the present case. But that HIDA status was revoked on November 22nd of 2023. But Mr. Evans has a conviction for CCW, a conviction for stolen property, receiving and concealing. So clearly, Mr. Evans' history shows he's a danger to the community, but also, Your Honor, he's a specific danger to the people associated with this case. Is a danger specifically to Jemai Wilson, who is an essential witness in this case, who is the only other adult who was at the apartment on the date of the incident, and the evidence supports that she had absolutely nothing to do with Kinsley Evans' injuries. Jemai Wilson has also at the initial outset provided statements to the police, which evidence that she is also a victim of Charles Evans, that she has dealt with physical assault and abuse at the hands of Mr. Evans as well. There are 3 children of Mr. Evans that are at a specific threat if Mr. Evans is let back out into the community. And Keandra Irving and her mother, Asia Nelson, and the rest of Keandra's family are at a danger as well if Mr. Evans is out in the community. And that is evidenced by phone evidence, Your Honor, that is quite frankly vile, gruesome. The threats that this man has made to the mother of the decedent in this case are, they're beyond anything that I've seen. Talking about loading 30 bullets in her father's face, so he has to have an open casket or closed casket, and everybody knows that she's the reason that he's dead. They're just very terrible threats in this phone evidence, Your Honor. So the danger to the community is evident based on Mr. Evans' history, but more specific, the danger to Jemai Wilson, his 3 surviving children, the mother of the decedent and her family is clear in this case. There is evidence to support that danger. And then lastly, Your Honor, as looking at a flight risk, I think that anybody facing these types of charges, there is an inherent flight risk, but also the main ties that this individual has to the community are really Jemai Wilson, who is an essential witness in the case, and clearly there would be no contact with Jemai witness during the pendency of this case. Also, his main connection to the community are his 3 surviving children, which clearly he will have no contact with during the pendency of this case. So his ties to the community are really limited from the people's perspective, Your Honor. And a tether is not going to protect the community and is not going to protect the people associated with this case. So we are asking for remand without bond. Thank you.
Thank you. Can you elaborate a bit more on the injuries to this complainant?
Yes, I can, Your Honor. Without going through the full, medical examiner's report, the injuries that are outlined in the medical examiner's report, there are multiple injuries. So there are multiple injuries to the face, to the forehead, the back of the scalp. When the medical examiner retracted the scalp of Kinsley Evans, there were multiple contusions on the underbelly of that scalp. There was hemorrhages, intracranial hemorrhages. There was the specific thing that the medical examiner noted that leads the medical examiner to believe that the main cause of death, that there are all these multiple injuries, right? But that the main cause of death, as outlined by the petechiae in the right eye, as well as retinal hemorrhages in the left eye, bilateral nerve hemorrhages, optic nerve hemorrhages, support the strangulation, because there was also significant injuries in the muscles of the neck as well. But there's really just multiple injuries in this case, Your Honor. There's also rib fractures. So the evidence supports physical assault and strangulation.
Thank you, counsel.
Thank you.
Mr. Gozer?
Thank you, Judge. Yeah, we are well aware of these charges and have been aware of these charges since the inception of the investigation on this case back in June. We had been inquiring about the process and where exactly what the people were going with this in terms of if they were going to issue a warrant, etc. I'd been in contact with the prosecutor's office, another prosecutor, not Ms. Wilmot, and had indicated our desire to cooperate as much as possible and trying to find out what exactly the process was. Then lo and behold, yesterday he was, or rather Friday, he was arrested, and my client contacted me, and I obviously informed him to surrender himself immediately to the authorities. Had we known that this warrant had been issued, obviously we would have walked him into the Detroit Police Department. He is not a flight risk. He hasn't missed any of his appointments, as I represented him for the probation violation, for which he had ample opportunity to escape. And yes, his case was closed out under probation, with probation being closed out and discharged. But again, that was not an assaultive case. The case that the people do discuss about is, it's interesting that the facts of that were that he allegedly had shot the victim, and then she recants. So that, and ultimately the case was dismissed. The people are saying that that is the basis for him to have remand because he's allegedly a violent person. But again, the case was dismissed after that complainant recanted. Now, the evidence that people talk about in the phone dump, we haven't received any of the discovery on this case. So I'm unable to comment on that and to say whether or not these things are taken out of context or not. So obviously, I'll leave that to the people's proof. But it does have more than just the context of his children. His father also resides here in the city. He has a home on Pearson Street, which he can go back to. The children that are with Hay and Jemiah are currently under custody of another party through the family court system. So he does not have access to those children. That being said, Judge, I think that a remand is a heavy bond, or no bond rather. We would ask the court to consider a cash bond with the tether on this matter in lieu of a remand.
Thank you. So the allegations here are horrific. We're talking about a 9-month-old baby who suffered very significant injuries while in the care and custody of Mr. Evans. Obviously, that child is now deceased. And I think the court here, I'm going to err on the side of caution with regard to safety of the community. And for that reason, Evans, you will be remanded to the custody of Wayne County Sheriff's for further proceedings in this case. Probable cause date will be March 27th, and preliminary exam will be April 3rd, both in front of Judge King, 36th District Court. Is there anything else for this record?
We would ask for, I'm sorry, go ahead, Ms. Woman.
Oh, thank you. And Your Honor, as it relates to the bond order, can you also add to the bond order? Obviously, there's no contact with any essential witnesses in the case, but I would ask if the court would indulge me and add the 2 specific names of Jemiah which is spelled Jimiah, last name Wilson, Wilson,
Mhm.
and Keondra, Keondra, Irving, which is Irving. That way it is specific as to those individuals in the order, so that I may submit that to the Wayne County Jail as far as access to calling them through the jail.
Will do. All right, sir. Obviously, no contact with any witnesses in this case, and specifically Jimiah Wilson and Keondra Irving. Is that clear, sir?
Yes, sir.
All right. Anything else, counsel?
Judge, I would ask the court if it would consider ordering a DSU report.
Can I do that, or does that come from a judge? He wants a DSU report. Can I order that, or will a judge order that at PCC? I bring that up with Judge King, counsel.
Very well. Thank you, Judge.
All right. Thank you. Have a great day.
You too.
Thank you, Your Honor. Everybody have a nice day.
Good afternoon, sir. What's your name, please?
Good afternoon, Your Honor. Marvin O'Neill.
Thank you. This is case 24-056-266, State of Michigan versus Marvin O'Neill, counsel.
Jennifer Douglas for the people, P72748.
Right on behalf of Mr. O'Neill, waive the reading stand duties provided.
Oral or not guilty on client's behalf as to bond.
Your Honor, on Mr. O'Neill, the people are asking for a higher personal bond of $25,000 personal, but tethering a curfew. Mr. O'Neill, tether house arrest. Sorry, Your Honor, tether house arrest. The reason people are asking for that, Your Honor, is Mr. O'Neill is currently actually on probation for an Oakland County case where he was sentenced September 26 to 23. I know the court can see that he has that the DD third. So he's been on probation for that since September 26 to 23. But I did check the register of actions, and I know that he was bound over to the Sixth Circuit Court on February 7th of 23. So at the time that this allegedly happened, he is on probation. So he was not bond, but he was on probation, seeing as how he was sentenced September 26 to 23. So, Your Honor, given that he's on probation for something assaultive, that here he allegedly was seen punching or assaulting somebody on the ground, and then he was resisting police. We do have some concern for safety of the public, but since we do know in the report it indicates that that other individual did not want to pursue charges, he still was allegedly seen assaulting somebody on the ground and then resisting arrest while on probation for an assaultive case. So $25,000 personal, tether house arrest.
So, Judge, I'm not going to object to the personal. I just don't know if the tether house arrest is appropriate for this. He doesn't want to have contact with the police or the complaints. I think police contact is the last thing Mr. O'Neill wants. So, Judge, I don't think you have to worry about that. So I don't think a tether is necessary. He lives with his mother, his two kids. He's waiting on his disability, Judge. Judge, he has seizures. He has a hairline fracture in his neck. He has back issues. He's got some medical things, Judge. But I don't think a tether's necessary, Judge. He's not going anywhere. It's not. It's gonna come to court. I think that the situation is a little bit more than what Ms. Douglas knows about in terms of other things, but and how the officers handled the situation at that time. But that's all going to come out, Judge. It's going to be between the officers and Mr. O'Neill in the court, Judge. And I think he will be present, and I don't think a tether is necessary.
Thank you. Ms. Douglas, you said he's already been sentenced in the Oakland County case. Is that correct?
Yes, Your Honor. He's on probation for that.
Deal with that, Judge.
Okay. So there's nothing else pending that you're aware of?
Not that I'm aware of, Your Honor.
All right. All right. I'm not going to do the tether. If he doesn't show up, we'll give him a cash bond the next time and not let him. Oh shit! What happened?
You all right, man?
He was about to get a personal bond.
Here, just sit here for a
He had
minute.
seizures, Ron. I was telling you he had seizures.
Yeah.
They call him.
Yeah.
Maybe that's
Man, can you just sit here?
let him see.
You hit your head.
Okay.
Yeah, he's conscious.
Okay.
We got a nurse coming down, so.
All right. Bond will be $10,000 personal. Next dates are March 26th, probable cause, and April 2nd, preliminary exam. Again, 10,000 personal, and maybe you guys can get him whatever aid he needs at this
We're
point.
taking him to healthcare right now. That was March 26th and April 2nd.
Correct.
Can you get your shoe back on, man?
This shit is embarrassing, man.
You got a personal bond. You leave it alone. Keep walking.